and just manner. That is all we ask under the Constitution, due process and the rights of all Americans. I yield back.
Gentleman yields back. Gentleman from Texas is recognized.
Mr. Chairman, I'll yield 2 minutes to the gentleman from Georgia, Mr. Gingrey.
Gentleman is recognized for 2 minutes.
Mr. Chairman, I appreciate Chairman Smith yielding to me, and with a great hesitation do I rise, because the gentlewoman who just spoke was recently rated the most eloquent, if not the most eloquent, one of the most eloquent members of this body. But even though she's eloquent, with all due respect, I think she's wrong. And in regard to the issue of the Commerce Clause and the issue of the Affordable Care Act, PAPACA, and sometimes referred to, and not really pejoratively, if it's successful, it will be his legacy, Obamacare. This bill, Mr. Chairman, was created by forcing individuals to engage in commerce, that is, to purchase health insurance, under the penalty or a tax. I'm not sure, from day to day how they're going to describe it. But without question, that's not constitutional. And I expect, maybe it'll be 5-4 decision in June of the Supreme Court, but maybe 9-0, because that is clearly unconstitutional. It is not applicable under the Commerce Clause to force people to engage in commerce. The Constitution says to regulate interstate commerce. And, of course, that is very much applicable in H.R. 5, in the Medical Liability Reform Act. Because when you have a situation in health care where there is no provision for certain medical specialties in a high-risk area like neurosurgery, obstetrics and gynecology, cardiovascular surgery, where babies have to be delivered beside of the road.
I'll yield an additional 2 minutes.
Yeah, I thank the gentleman for yielding. But clearly, the gentlelady from Texas, and I think she knows this. Texas has enacted tort reform. They have caps that are different, in fact, than originally existed in California 35 years ago. And the result in Texas, if all of my colleagues from Texas on this side of the aisle are truthful with me, is that the problem in Texas is stabilized. Physicians are coming back to Texas. There is no shortage of specialists because of the law that was passed in Texas. And I want to point out to the gentlewoman, too, that in this bill there is a provision called flexi caps that basically says whatever a state does preempts federal law in regard to caps on non-economic, as well as contingency fees for plaintiff's attorneys or any other provision of the law. State law prevails if they address that either before this bill is passed or after the bill is passed. So I just say, and I will yield momentarily, but the gentlelady is eloquent, but she's wrong on this issue, and I will yield to her.
Dr. Gingrey, thank you for your kindness and your kind words. And so I would say that rather than being wrong, we disagree. But what I would say is if you do not have a cap, then this bill will supersede the laws in states that say they have no caps. And the only thing I would conclude on is that the premise of your bill is premised, even though you're citing the individual mandate, and we can quarrel about that as to whether or not it is a forced upon mandate, whether there are options of that individual having employer-based insurance, etc. But it is premised on interstate commerce, and therefore you have an amendment being offered by one of your members to strike that because
Mr. Chairman, you're back.
I have 15 seconds.
I yield the gentlelady an additional minute.
I thank the distinguished gentleman.
Ladies recognized for an additional.
And I thank the gentlelady from California as well for her courtesies. The premise of this bill is interstate commerce, of which in the initial arguments being made by my friends on the other side of the aisle, they argued vigorously that we couldn't even do health care under this premise, even though we have Medicare. The premise you have in this bill is under interstate commerce, but you have an amendment that is seeking to strike your findings because you were caught with a conflict between dealing with this question congressionally, which we're saying is legitimate from the perspective of the Affordable Care Act. You're trying to use it now, but you realize that there are members who are now arguing the question of states' rights. We have existing state law on tort reform, hundreds of years of tort reform, and you're trying to abolish it with this added legislation on medical malpractice. You're now trying to supersede state existing law.
I yield the gentlelady another minute.
Gentleman yields
and
a minute.
Where the amounts of monies are not capped, where there are no caps, this bill places the $250,000 in. If there are no caps, that is a overriding of state law. No matter how you cut it, it's an overriding of state law. And I ask my colleagues, you can't have your cake and eat it too. I'm willing to celebrate the Affordable Care Act and eat the cake because it saves lives. But what you're doing here now is not. You're overriding state law, many states. And I yield back to the gentleman. And I thank the gentleman for his courtesy.
Gentleman from Texas is recognized.
Mr. Chairman, I'll yield 4 minutes to the gentleman from Arizona, Mr. Quayle, who's an active member of the Judiciary Committee.
Gentleman's recognized for 4 minutes.
Thank you, Mr. Chairman, and I thank the gentleman for yielding and for his work on this important piece of legislation. And Mr. Chairman, I rise in support of H.R. 5, the PATH Act, because our country is in urgent need of medical malpractice reform. Currently, we have a jackpot justice system that is not based in reality, and it's badly damaging our country's healthcare system. Now, profiteering attorneys know this, and that's why the number of malpractice suits have been precipitously rising year over year. Back in the 1960s, 1 out of 7 physicians would have had a malpractice claim over their entire lifetime. Today, it's 1 in 7 physicians are sued each year. That is an astronomical jump in the number of claims that are being put on doctors. And the doctors are now being forced out of the profession even when they haven't done anything wrong. The practice of defensive medicine is harming the quality of care and pushing up costs. And the enormous expense of insuring a doctor against liability is making healthcare inflation much worse. Not to mention the fact that the current system is damaging the doctor-patient relationship. It damages it in a way because every doctor has to see every interaction with the patient as a potential lawsuit. That is not what the doctor-patient relationship should be built on. It should be built on mutual respect and trust. And until we have something that actually addresses the medical malpractice problems that we have, and we get the reforms that are much needed, that actual relationship is never going to improve. So I urge the House to pass the PATH Act because it will do 2 vital things to get health care costs under control. First, it would eliminate Obamacare's Independent Payment Advisory Board and thereby keep a board of unelected, unaccountable bureaucrats from restricting senior access to health care. It also brings medical malpractice lawsuits under control by capping non-economic damages and limiting attorneys' fees so more money will actually go to the victims rather than overzealous trial lawyers. These reforms will save taxpayers over $40 billion over the next decade. Everyone knows that we need to do something about rising health care costs, and this bill and taking care of the medical malpractice problems that we have will go a long way in getting those costs under control. This vote will give every member of this House the opportunity to be part of the solution, and I urge my colleagues to vote yes on H.R. 5, and I yield back.
Gentleman yields back. The gentleman from Michigan is recognized.
Thank you, Mr. Speaker. I yield to a senior member of the Judiciary Committee, Maxine Waters of California, as much time as she may consume.
Gentlewoman is recognized for as much time as she may consume.
Thank you very much. Mr. Conyers, former chair of the Judiciary Committee, ranking member, and a gentleman who's provided superb leadership in opposition to H.R. 5. Mr. Speaker, I rise in strong opposition to H.R. 5, poorly titled Protecting Access to Health Care, so-called PATH Act, an unconstitutional big government bill that violates the 10th Amendment and states' rights. At the very start of the 112th Congress, my colleagues on the opposite side of the aisle declared that all business conducted in the House would be consistent with the Constitution. Yet, if you read the constitutional authority statement attached to H.R. 5, the Republican sponsors seem to believe the Commerce Clause magically creates a path for Congress to mandate nationwide caps on punitive damages in all medical malpractice lawsuits. The Republicans are telling all Americans, no matter how severe the injury or egregious the mistake by the doctor, hospital, or drug manufacturer, that their losses are going to be capped at $250,000. And with all due respect to the gentleman from Georgia, Representative Gingrey, who introduced H.R. 5, even his own state Supreme Court has found caps on punitive damages to be unconstitutional. In 2010, the Georgia Supreme Court unanimously struck down limits on jury awards in medical malpractice cases. The Georgia court determined that $350,000 cap on non-economic damages violates the right to a jury trial as guaranteed under the Georgia Constitution. Section 110A of H.R. 5 would impose an even lower cap on damages in Georgia, effectively overturning the court's decision by an act of Congress. The section reads, the provisions governing health care lawsuits set forth in this act preempt, subject to subsections B and C, preempt state law to the extent that state law prevent the application of any provisions of law established by or under this act. In addition to Georgia, other states like Arizona, Pennsylvania, Wyoming, and Kentucky, whose state constitutions specifically prohibit damage limitations, will have their constitutionals overruled by Congress. For members who have for years now questioned the constitutionality of the Affordable Care Act, you need but take a look at H.R. 5. H.R. 5 goes far beyond anything passed by the Democratic majority. If you don't believe me, just listen to Tea Party founder Judson Phillips. In slamming H.R. 5, he wrote, whether you think tort reform is a good idea or not, it is an issue that belongs to the states and not to the federal government. Tort law has always been governed by the states. Now, I didn't say that. Mr. Conyers didn't say that. Ms. Jackson Lee didn't say that. None of those who have been over here this evening opposing H.R. 5 and laying out the facts and the consequences of H.R. 5 said this. Let me repeat. I am quoting Tea Party Nation founder Judson Phillips. Whether you think tort reform is a good idea or not, he said, it is an issue that belongs to the states, not to the federal government. Tort law has always been governed by the states. Even some of my Republican colleagues on the Judiciary Committee have expressed concerns. Congressman Poe, Republican from Texas said, I believe that each individual state should allow the people of that state to decide, not the federal government. If the people of a particular state don't want liability caps, that's their prerogative under the 10th Amendment. Well, let's listen to what Congressman Louis Gohmert, a Republican of Texas, said. He said the right of states for self-determination is enshrined in the 10th Amendment. I am reticent to support Congress imposing its will on the states by dictating new state law in their own state courts. To my conservative colleagues in this chamber, don't be tricked, don't be fooled. H.R. 5, simply, clearly put, violates states' rights. Reject this unconstitutional piece of legislation. Protect states' constitutional rights to set tort law, and just vote no on H.R. 5. Now, let me just wrap this up by saying the gentleman from Georgia referred over and over again, constantly this evening, about frivolous Californians. And he talked about these juries who didn't take into consideration the facts on these negligence cases, but rather looked at the insurance and said, oh, just give them whatever. They didn't care. Well, I came to defend California and to tell you the difference between what happened in tort reform in California and what you're being told by the gentleman from Georgia. Supporters of H.R. 5 claim that is the same as MICRA, a medical malpractice liability law passed in California in 1975. H.R. 5 is far different from MICRA, except that neither law delivered on lower insurance premiums. The differences are clear. H.R. 5 applies damage caps in all health care lawsuits, including cases against drug companies, nursing homes, insurance companies, and HMOs. MICRA only applies to malpractice cases against a doctor or a hospital. Punitive damages are reserved for only the most egregious medical malpractice. They are meant to deter future dangerous conduct. H.R. 5 limits punitive damages. MICRA does not cap punitive damages. H.R. 5 gives total immunity from punitive damages to drug and device manufacturers if their products have been approved by the FDA or are generally recognized as safe and effective. MICRA does not provide this kind of sweeping immunity for the drug industry. H.R. 5 caps non-economic damages at $250,000 in the aggregate, no matter how many parties have been damaged by medical malpractice, even when an injury results in loss of a marital relationship. California law recognizes a separate claim for loss of consortium claims brought by the spouse of an injured patient. MICRA does not limit these claims. Joint and several liability, which my leader asked you about, Mr. Gingrich, enables an individual to bring one claim against any of the parties involved in a medical malpractice injury and ensures that injured victims are fully compensated. H.R. 5 completely eliminates joint liability for both economic and non-economic losses. California law only limits joint liability for non-economic damages. H.R. 5 and MICRA are alike in one main respect by themselves. Neither law can deliver on lower medical malpractice insurance premiums. H.R. 5 includes unprecedented legal protections for the insurance industry, but no guarantee that any future savings will be passed on to doctors or patients. Following the passage of MICRA, insurance premiums for doctors increased in California by 450% over the next 13 years. Premiums not only decreased after California enacted Proposition 103, a ballot initiative that mandated a 20% rollback in premium rates. I was in the California legislature when that happened. H.R. 5 does not guarantee lower premium rates for doctors. In fact, the bill only mentions insurance companies when giving them protection from liability. So, again, I said don't be fooled, don't be tricked. I don't really mean to imply, Mr. Gingrich, that you are trying to fool or trick anybody, but you're simply wrong. we have given our opposition in more ways than one this evening to H.R. 5. But since you alluded to or talked about or pointed directly to California and all of these people who simply have frivolous lawsuits and these poor juries who sit and don't take into consideration the facts and simply look at how much insurance is available and just award these tremendous amounts, I had to add to my testimony this evening a defense and an explanation and show the difference between MICRA and H.R. 5. And I think I have done that, and I think I have done that with the facts that exist, and I am very pleased that I have been able to join with my colleagues this evening to not only reveal what H.R. 5 is and is not, but I think we've made the case. And I think that we have put the facts forward in such a way that we're going to win on this issue. I ask you to oppose H.R. 5.
Gentlelady yields back. Gentleman from Texas is recognized.
Mr. Chairman, I'll yield as much time as he may consume to the gentleman from Georgia, Dr. Gingrich.
Gentleman's recognized for as much time as he may consume.
Mr. Chairman, I thank Chairman Smith for yielding to me. As good a communicator as the gentlewoman from California is, I would be quick to state that she's not the great communicator. The great communicator, of course, President Ronald Reagan. And the gentlewoman from California talked about the comments that were made on my side of the aisle, members of the Judiciary Committee, and named a couple of members on my side of the aisle that were concerned about federalism and the 10th Amendment and states' rights. But I just want to remind her that, at least from our perspective, the gentlewoman may not agree with this at all, but from our perspective on this side of the aisle, the great communicator was President Ronald Reagan. In speech in 1986 to the U.S. Chamber of Commerce, after a commission had reported to him on this issue of medical liability reform and the need for same, the President very clearly outlined almost the identical provisions that are part of MICRA, a Medical Injury Compensation Reform Act, that was passed in his state that he governed for 8 years, the great state of California. So, you know, again, the gentlelady makes her points well, but quite honestly, I think there's, you know, a bit of embellishment. I think on their side of the aisle, who do you trust? The gentleman from Arizona, Mr. Quayle, just spoke moments ago, Mr. Chairman, about who do we trust? Well, right above you, as you sit there, first of all, in God we trust. In Mom and Dad we trust. In Dr. Bailey, Augusta, Georgia, we trust. In Uncle, we trust, but that's way down the line, way down the line. I think our colleagues on the other side of the aisle think that big government should control everything, that they should make the decisions, and that's where Obamacare came from. And to do it, they had to proffer a 2,800-page bill that is clearly unconstitutional. H.R. 5 is not unconstitutional. You look at Article 1, Section 8, Clause 3, the Commerce Clause, and clearly it's constitutional, requiring someone, forcing someone to engage in commerce, indeed to purchase health insurance under the penalty of a tax, is unconstitutional, and that will be determined by the Supreme Court. With that, Mr. Chairman, I yield back.
Gentleman yields back. Gentleman from Michigan is recognized.
Mr. Speaker, we have no further requests for time, and with the agreement of the chairman of the committee, I would like to close at this point.
Mr. Chairman, we have no other speakers as well, and I'm prepared to close on this side.
And I
Gentleman from Michigan is recognized.
I'd like to thank all of the members on both sides of the aisle that have participated in this important debate. There has been a lot of clarity, even though there has been a great difference in opinion. I return the balance of our time with this thought in mind, that even though the author of this bill is a well-regarded medical practitioner and who is a distinguished member of the body, he is a doctor, but he is not a lawyer. And I think that and I commend him on the fact that he agreed with this statement that, to me, determines a lot of people's point of view about this very controversial bill that is now before the floor, H.R. 5. That is, he agreed and answered in the affirmative that H.R. 5 eliminates joint and several liability for both economic, non-economic, and punitive damages. And to me, with all of the cases that have been of human suffering, of injury to women and children, of how wrong it would be to limit all of these kinds of damages to $250,000 in this 21st century is an insult to common sense and fair play. With pleasure.
And I appreciate very much you yielding to me for that, because clarification needs to be made. You're suggesting that what I said was there would be a limitation of $250,000 because of the elimination of joint and several liability. That's not true at all. Whatever the judgment is, the $250,000 in non-economic, the $10 million in economic would be apportioned to the defendants in proportion to their liability. That's what the elimination of joint and several liability means, eliminating this deep pocket mentality of plaintiff's attorney.
Well, I accept your comments. I accept, through the speaker, I accept the comments of the gentleman from Georgia, and I assume that his response to my question earlier is still yes. And if that is the case, then all I can say is that I think there are very few people in the federal legislature or among our citizenry that would say that there should not be a unlimited amount of recovery. The gentleman must have some feeling for the fact that $250,000 for the rest of the person's life, if they lose arms or legs, eyes, it's just unacceptable. I won't say that it's immoral, but it's unfair. And it's my hope that most of our colleagues, as we continue this debate tomorrow, will realize that that is the fatal flaw in a bill that may have some justification in other parts of it, but that limitation of damages cannot be rationalized nor justified by the collective body of this legislature. And for that reason, sir, I am urging all of our colleagues to consider this one point that I make tonight as I close as to be controlling in their decision that they will make as we vote tomorrow on this bill. And I thank all of the members that have joined in this debate this evening. And, Mr. Speaker, I return the balance of my time.
Gentleman's time has expired. Gentleman from Texas is recognized.
Mr. Speaker, I yield myself the balance of my time. Mr. Chairman, I just want to reemphasize again that under this bill, awards are possible that far exceed the $250,000 cap in non-economic damages. And that's because under the economic damages provision, there is simply no cap. And as a result of that, states like California and Texas, which have adopted reforms very similar to the reforms in this particular piece of legislation, there have been numerous awards of multi-million dollars awarded to individuals who have been injured. So even though we have that $250,000 non-economic cap, that is not an absolute cap on the awards that have been made. A minute ago, Dr. Gingrey mentioned that in California, for example, several years ago, I believe it was 2007, there was a $96 million award. And in the last year, for which we have records in 2010, there were awards, I think, for over $6 million, over $10 million, over $14 million. So an individual is able to be reimbursed for the cost and injuries that that individual may have incurred. Mr. Chairman, I also want to say that America's medical liability system increases the cost of health care and decreases access to care as doctors abandon their practices and avoid high-risk specialties out of fear of being sued. Medical liability reform, this bill tonight, will solve this problem. According to the Journal of the American College of Surgeons, 5 years after tort reform legislation passed in my home state of Texas, the number of physicians in the state increased by 24%. That is twice the rate of growth in population over the same period of time. Other states have seen similar results. But most states have not enacted meaningful reforms, and as a result, frivolous lawsuits have created a medical liability crisis. This crisis has forced women to drive great distances to deliver their babies because their local hospital doesn't have an OB/GYN. It has resulted in those who need complicated procedures being placed on waiting lists for months because the only available specialist has too many patients who seek care. And it has caused accident victims to lose their lives because their local emergency room no longer has a trauma center. America's broken medical liability system has caused patients to lose access to high-quality health services. The liability reforms contained in the Health Act will do these things. Will lead to a significant savings in health care expenses, reduce the practice of defensive medicine, halt the departure of doctors from high litigation states and medical specialties, improve access to health care, and increase the affordability of health insurance. Also, according to the Congressional Budget Office, this legislation will reduce the federal deficit by more than $45 billion over the next 10 years. This is a significant savings in a time of escalating deficits and debt. We've seen the positive effects that similar medical liability reforms have had at the state level. Reforms in states like California and Texas have enhanced patient care, reduced doctor shortages, and decreased cost. It's time for Congress to enact these reforms for the benefit of all Americans. And, Mr. Chairman, before I yield back the balance of my time, I'd like to thank the gentleman from Georgia, Dr. Gingrey, who has spoke so well so many times tonight, for introducing this piece of legislation that is going to help so many people across America. With that, I'll yield back the balance of my time.
The gentleman yields back, and all time for general debate has expired. From what purpose does the gentleman from Texas rise?
Mr. Chairman, I move that the committee as a whole now rise.
The question on the motion that the committee rise, all those in favor say aye. All those opposed say no. The ayes have it. The motion is adopted, and accordingly the committee rises.
Mr. Chairman.
Mr. Speaker, the Committee on the Whole House on the State of the Union, having had under consideration H.R. 5, directs me to report that it has come to...
The Chairman of the Committee of the Whole House on the State of the Union reports that the committee has under consideration H.R. 5 and has come to no resolution thereon. Request for 1-minute speeches. Chair lays before the House the following personal requests.
Leave of absence requested for Mr. Backus of Alabama for today and the balance of the week, and Mr. Davis of Illinois for today and Thursday, March 22nd.
Without objection, the requests are granted. Under the Speaker's announced policy of January 5, 2011, the gentleman from New Jersey, Mr. Pallone, is recognized for 38 minutes as the designee of the Minority Leader.
Come to the floor this evening basically to talk about the Affordable Care Act. Some call it the health care reform. This Friday will be the second anniversary of the President's signing of the Affordable Care Act, or health care reform. And I'd like to talk a little bit about how it's helping so many people with patient protections and added benefits, whether you're talking about seniors or young people or women or just the general public. The main thing that is heralded, if you will, by the Affordable Care Act is the opportunity over the next few years to expand health insurance to so many Americans who do not have health insurance now. We estimate there are variously between 40 maybe 45 million Americans that simply have no health insurance. And what that means is they either don't go to a doctor or they don't get any kind of health care unless they get very sick and end up going to the emergency room. And the consequences of that is that they take no preventative care. They end up in the emergency room. Oftentimes they can't afford to pay the cost of the emergency room, and that cost simply gets passed on to the hospital or ultimately to everyone else who is paying for health insurance. So basically what the Affordable Care Act does over the next few years is try to expand insurance coverage to something like 98–99% of all Americans, taking up those 45 million people and for the most part making sure that they have health insurance. It does that in two basic ways. First of all, it expands Medicaid, which is the health insurance program for people below a certain income. About 15 million Americans who have no health insurance now would be eligible for Medicaid under the Affordable Care Act over the next few years when it kicks in. In addition to that, for the rest of the Americans who have no health insurance, most of them are people that either don't get it on their job, they're not eligible, or they're not offered health insurance by their employer, or they may be individuals who are employed on their own or at home or not employed in some capacity. They have a very hard time buying a health insurance policy on what we call the individual market. So what the Affordable Care Act does, it sets up exchanges in every state or throughout the country where you can get a very good package for a reasonable price, a very low-cost price, and at the same time it provides a subsidy through tax credits to many Americans depending upon their income. We estimate if you're for a family of 4 making up to $70,000 or $80,000 a year would be eligible for some sort of subsidy or tax credit that would make their health insurance policy more affordable. So essentially what we do is between expansion of Medicaid and the subsidies, if you will, and the low-cost insurance that's offered now on these exchanges around the country, most people would end up with health insurance. Now, what I wanted to talk about today are some of the benefits, if you will, that have already kicked in for various groups of people, particularly seniors. I wanted to start with seniors, because many seniors, as you know, because they're on a fixed income, have a hard time making ends meet. Oftentimes, you know, they can't afford their rent, they can't afford food, and for them to take extra money out of pocket to pay for health care costs is oftentimes very difficult. And they have to make choices between, you know, heat or food as opposed to health care. One of the things that I really want to stress today, because I listened in the last few nights because of the anniversary of the Affordable Care Act coming up on Friday, I've heard some of my colleagues on the Republican side of the aisle actually suggest that somehow the Affordable Care Act was going to negatively impact Medicare. Nothing could be further from the truth. In fact, the Affordable Care Act expands benefits for seniors under Medicare in many significant ways. But it's particularly interesting that I hear that from the other side of the aisle, from the Republican side of the aisle, this week, because on Tuesday, the Republicans unveiled their budget for the next fiscal year. And once again, as they did last year in last year's budget, the Republican budget this year essentially gets rid of Medicare, or what I would say ends traditional Medicare. So it's kind of strange to hear the Republicans talk about Medicare and the Affordable Care Act, since the Affordable Care Act actually expands benefits for seniors under Medicare, whereas they unveiled their budget this week that actually abolishes, for all practical purposes, Medicare as we know it. What the Republican budget does, once again, is say to seniors, well, we're going to give you a voucher. We're going to give you a certain amount of money through a voucher, if you will, and you can take that and go out and buy private insurance instead of getting the guaranteed benefit under Medicare that seniors now have. The problem with a voucher is that it's a fixed amount of money, and it's not at all clear that seniors can buy health insurance with the voucher. But even if they could, because it's a fixed amount of money and it doesn't increase significantly over the years, what you'll find with that voucher is that more and more seniors would have to pay out of pocket either to purchase the insurance because the voucher is not enough, or because they probably can't get a decent package equivalent to the Medicare guarantee, and therefore would have to pay out of pocket for certain costs that are not covered by the health care plan that they purchased with the voucher. So it's sort of ironic to hear the Republicans talk about the Affordable Care Act and suggest that the Affordable Care Act should be repealed because of its impact on Medicare, when in fact they're doing their best under the budget to basically end Medicare as we know it. Now let me talk a little bit about some of the benefits. I want to talk about how the Affordable Care Act helps seniors, and then a little bit about how it helps women, and then a little bit about how it helps young people. Of course, it helps everybody by simply expanding health care coverage for those who don't have health insurance. But the benefits in particular I want to talk about and start with seniors. I mentioned before that no group has been hit harder by soaring health care costs than seniors. With the economy struggling over the last several years, seniors have suffered even more as they've watched many of their pensions and investments dwindle, making the cost of addressing their health care needs even more challenging. Now, as a result of the Affordable Care Act, some of the financial burdens plaguing seniors trying to manage their health care needs have been alleviated. For example, all Medicare beneficiaries now have access to preventative care and services without any copay, coinsurance, or deductible. Many times you will find that seniors won't even access health care because of the copay, which is about 20% in most cases. So now services like annual wellness visits, cholesterol and other cardiovascular screenings, mammograms, cervical cancer screenings, prostate cancer screenings are completely free of charge to seniors, no copay. I stress that. No copay. Fact of the matter is that the Affordable Care Act expands benefits for seniors, makes it so seniors pay less, okay? More than 32.5 million seniors nationwide have received one or more free preventative services. 2.3 million seniors have already received a free annual wellness visit to their doctor, which again is a critical step in preventing more serious illness, because if the senior citizen goes for the annual checkup or has some of these preventative services free of charge, then that avoids them having to get sicker, ending up in a nursing home or ending up in a hospital. The most important thing, though, in terms of expansion of benefits under the Affordable Care Act for seniors is the closing of the Medicare Part D donut hole. Seniors, on the average, before the Affordable Care Act, would run out of their Part D benefit on the average by September of the year. In other words, if they spent more than $2,500 approximately on drugs, they wouldn't get any help under Medicare Part D until they got to a higher catastrophic level of $5,000. So that was the donut hole, that gap when they weren't getting any money to help pay for their prescription drugs. What the Affordable Care Act does is it closes the Medicare Part D donut hole and provides a 50% discount on brand-name drugs. 3.6 million seniors have already received the discount, saving a total of $2.1 billion, with each senior saving an average of $604. Now, by 2020, that donut hole is closed completely. Now it's a 50% discount, but gradually that will close to the point by 2020 when all their drugs are covered and the donut hole ceases to exist. I also want to stress that the Affordable Care Act has cracked down on fraud in Medicare. In fiscal year 2011, a joint anti-Medicare fraud task force of the Health and Human Services Department, Department of Justice, recovered more than $4.1 billion in fraudulent Medicare payments on behalf of taxpayers. A lot of times I hear my senior citizens will say to me, well, there's a lot of fraud in Medicare. There is. But the Affordable Care Act has significantly cracked down on a lot of that fraud. $4.1 billion in fiscal year 2011. Now, you know, I say this, I mention this again by way of contrast. Here we are in the Affordable Care Act expanding benefits, making it so seniors don't have to pay more, and what are the Republicans doing with their budget? They have a budget that basically says, we'll give you a voucher, you go out and buy your health insurance. If you can't afford it, you have to pay the difference. And I guarantee the basic guarantee of Medicare and a good benefit package simply won't be there, and seniors will just end up paying more out of pocket. Now, I wanted to talk a little bit about how the Affordable Care Act levels the field for women's health care, because we know that traditionally in health care there's been a huge gender gap. A report issued this week from the National Women's Law Center shows that more than 90% of the best-selling health plans still charge women more than men for the same coverage just because women use more health services. The health care law, the Affordable Care Act, will prohibit this discriminatory practice, which we call gender rating, beginning in 2014, so that when the Affordable Care Act fully kicks in, this gender gap will simply disappear. Now, you might say to yourself, well, how's that possible? It's mainly because insurers have considered millions of women as having what we call pre-existing conditions. In other words, they were denied coverage or they were charged more for having had breast cancer, cesarean section childbirth, having even been pregnant. Some policies would charge women more because they were pregnant or consider that a pre-existing condition. Or for being victims of domestic abuse, for example. So denying women insurance on these grounds is unconscionable, and thanks to the Affordable Care Act, beginning in 2014, women will no longer be denied coverage by any insurers based on these pre-existing conditions, and they can't be charged more because of the pre-existing conditions. Now, we've seen, again, by contrast, what have the Republicans been doing? They say repeal the Affordable Care Act, which would let these pre-existing conditions and this gender gap continue. But beyond that, over the last year or so, we've seen the Republicans essentially declare war on women. And I just want to give you an example. One of the ones that's received the most attention lately is are these attempts by the Republicans to block access to contraception. I don't know how far they're going to go in terms of denying women coverage, but that's one of the things that we've seen in the headlines for the last few months or so. But let me give you some other examples under the Affordable Care Act. Insurance companies are now prohibited from requiring women to obtain a pre-authorization or referral for access to OBGYN care. Healthcare reform also requires insurance plans to cover important preventative services, including critical immunizations, numerous health screenings, and counseling services with no cost sharing by women. Women in new private plans under the Affordable Care Act, they provide free coverage of important life-saving preventative services. But the other thing that would often happen is that many health insurance plans had what they call lifetime dollar limits on health benefits, so that if a woman, this would be true for anyone if they had that lifetime dollar limit in it, but oftentimes it was applied to women in particular, that if you spent a certain amount of money on your health care over your lifetime, that was it. You didn't get any more coverage under your plan. So that is also prohibited under the Affordable Care Act. Now, just mention those few things that apply to women, because there really continues to exist a gender gap, but that will be closed and eliminated under the Affordable Care Act when it completely kicks in. Now, the last group I wanted to mention, just because I've always felt that many times in Congress we don't pay a lot of attention to kids, and I felt that it's very important for us to recognize the fact that policies and the practices and the laws don't necessarily help children, and children are very vulnerable. It's like, you know, the seniors are vulnerable, the children are vulnerable. Well, one of the things that's significant about the Affordable Care Act, it really makes a difference for children in terms of keeping them healthy and also keeping them insured. And a lot of times Americans have to make choices with regard to their kids about, you know, whether they're going to have afford health care services because of the prohibitive cost of insuring children. Now, under the old system, before the Affordable Care Act, sick children were often denied health coverage if their parents were forced to change insurance because they either switched or lost their jobs. Insurance companies declined or dropped coverage for children, and when young adults got sick or had an accident. That's no longer the case. Under the Affordable Care Act, basically, there's a prohibition on insurers denying coverage to children under age 19 for having a pre-existing condition. Up to 17 million children with pre-existing conditions are now protected from that type of discrimination. Currently, there are 7.3 million American children without any health insurance. Beginning in 2014, the law will provide access to quality coverage. That's, again, by expanding Medicaid coverage and also by providing affordable insurance on these exchanges with a tax credit or some kind of help from the federal government to pay for the insurance. The other thing I wanted to point out, though, and this is really significant because, again, it's kicked in, and I've had many of my constituents come up to me and mention it, and that is that the Affordable Care Act requires health plans to allow parents to keep children under age 26 without job-based coverage on their family's coverage and give millions of parents and young adults the peace of mind that they can start their lives and careers without being crippled by health care expenses. What happens is, because of the economy and the difficulties we had with the economy over the last few years, a lot of people, a lot of kids or young adults, when they graduate high school, when they graduate college, are not able to find a job, or while they're in college, they can't afford health insurance on their own because they have to go out and buy it on the individual market. So what the Affordable Care Act says, that you can be kept on your parents' policy, and the insurance company has to provide that option up to the age of 26. Very significant. Millions of young people that did not have coverage are now covered by that under their parents' policy. Now, I just wanted to take a couple more minutes. I wanted to give some examples in my district, in the 6th Congressional District in New Jersey, about some of the numbers of people that have been impacted in a positive way by the Affordable Care Act. And these statistics come from my committee that I serve on, the Committee on Energy and Commerce. And just to give you some idea, in my district, in the 6th District of New Jersey, 6,800 young adults in the district now have health insurance that didn't have it before. 9,100 seniors in the district receive prescription drug discounts worth $6.9 million, an average discount of $760 per senior. This is for their prescription drug coverage. 63 63,000 seniors in the 6th District of New Jersey received Medicare preventative services without paying any copays, coinsurance, or deductibles. 31,000 children, 130,000 adults now have health insurance that covers preventative services without paying any copays, coinsurance, or deductibles. 620 small businesses in the 6th District received tax credits to help maintain or expand health insurance coverage for their employees. $1.8 million in public health grants have been given to community health centers, hospitals, doctors, and other healthcare providers to improve the community's health. Community health centers have really expanded in the district because of the Affordable Care Act. And 8,000 to 35,000 children with pre-existing health conditions can no longer be denied coverage by health insurers. I could give you more statistics, but I just want to point out that this is impacting, these benefits under the Affordable Care Act are impacting constituents in every district in the country, not just mine, thousands of people in my district, but all over the country, millions of people. Now, I just wanted to talk a little bit about the cost issue, because I always hear the Republicans say, oh, you know, your costs are going to go up because of the Affordable Care Act. In fact, costs for health insurance now without the Affordable Care Act have gone up. But the Affordable Care Act actually is reducing costs for health insurance. Whatever cost increases you're exhibiting now are because the Affordable Care Act hasn't gone into effect completely. It kicks in gradually over the next few years. And so I hear some of my Republican colleagues say, oh, you know, your health insurance went up. Well, that's because it hasn't kicked in yet. Once it kicks in, there are a lot of positive impacts on costs that will make a difference. But let me just talk about some of the statistics in terms of costs that I think are significant. Since enactment of the health care law, the reform, the ACA, premiums are generally lower or stable. Average premiums for Medicare Advantage enrollees are 7% lower in 2012 than they were in 2011. And since the health care law was enacted, these premiums have fallen by 16%. Average premiums for Medicare Part D, the prescription drug program, in 2012 have seen no increase from the 2011 level. The Medicare Part B deductible has fallen by $22 to $144 in 2012, the first time in Medicare history the deductible has actually fallen. For most Medicare Part D enrollees, the standard Part B premium in 2012 is quite stable, 3.6% higher than the premium they paid in 2011, matching the 3.6% COLA increase seniors are receiving in their Social Security checks. And finally, the growth in private plan premiums has also slowed. In September 2011, Mercer, an independent benefits consulting firm, released a survey of employers showing that health insurance premium increases will average 5.4% in 2012, the smallest increase it's measured since 1997. Now, despite Republican claims, the health care law has played essentially no role in recent private plan premium increases. In fact, the premium increases have taken effect only because the ACA has not fully kicked in at this point. And there are two provisions that I want to mention that deal with cost and that address cost in the Affordable Care Act that I think are significant and that put downward pressure on premiums. One is the rate review, and that is that under the health care law there's new transparency and accountability for insurers, with insurers required to publicly justify on the Internet any premium increases they're seeking that are over 10%. And the Department of Health and Human Services has rate review authority to publicly deem these increases to be unreasonable. And they've done that in a number of states. The health care law also provides $250 million in health care insurance rate review grants to the states to make them enforce and keep premiums down. And finally, under the health care law, insurers must spend at least 80% of premiums on medical care and quality improvement rather than CEO pay, profits, and administrative costs. If insurers don't meet these standards, they have to pay rebates to their consumers starting this summer. So these are significant ways of cutting back on costs. Now, what do we see from the other side of the aisle? Again, repeal the Affordable Care Act. Well, if the Affordable Care Act were repealed, all the things that I talked about would disappear. Costs would climb. More and more people would have no insurance. All the benefits for seniors, the fact that you can have your children on the policy till 26, the gender gap for women, all these things, all the benefits would disappear, and only the bad impacts from insurance companies and being able to do whatever they want would remain. Now, so that Republicans talk about repealing the Affordable Care Act. They don't say what they would substitute for it. But what we do know, and again, this week, and I'm going to close with this, Mr. Speaker, this week we heard from the Republicans in terms of what they want to do with their budget. And again, what does their budget do? It essentially privatizes Medicare, makes it into a voucher program, causing seniors to spend more money out of pocket for the type of guaranteed benefits that they receive now under Medicare. It even goes and impacts Medicaid. A lot of seniors or a lot of people are not aware of the fact that Medicaid, which most people see as a program for poor people, actually pays most of the costs for nursing home care in this country. Because what happens is that if you have to go to a nursing home, you have to spend all your assets, essentially, with few exceptions, on paying for that nursing home care. And then after you have no assets left, the Medicaid kicks in and pays for your nursing home care. Well, what do the Republicans do in their budget? They basically slash Medicaid. They block grant it to the states. They slash it from 20 to 30% based on, however, different accounts. 20 to 30% slash in the money that goes back to the states because the states have to match Medicaid. And they abolish the expansion of Medicaid that I mentioned before under the Affordable Care Act because they assume under the budget that the Affordable Care Act is going to be repealed. So not only is there a negative impact on Medicare because it becomes a voucher and essentially traditional Medicare disappears and seniors pay more out of pocket, but with regard to Medicaid, which pays for nursing home care, the states are going to get so much less money that the quality of nursing home care will seriously diminish. I remember back in the 70s when you would go to many nursing homes and they were terrible places because we upgraded them and we provided money to the states to pay for Medicaid that they matched so that the quality of nursing homes improves significantly. What will happen, and I'm not just telling this, nursing home industry has said this, with these types of cuts that are being proposed in the Republican budget, a lot of nursing homes will close and their quality of care will diminish. They won't have as many nurses on staff. They won't be able to do a lot of the things they do now to make people's lives more comfortable in nursing homes. And the budget assumes the repeal of the Affordable Care Act, which means that expansion of Medicaid, the subsidy pays to pay for health insurance, all the things that I talked about before would simply disappear. So I know I make a stark contrast between what the Republicans are proposing and what we're doing with the Affordable Care Act and trying on the Democratic side to shore up and expand Medicare benefits. But the fact of the matter is it is a stark contrast. Very stark contrast in terms of a worldview of what we're going to do in terms of health insurance coverage, what we're going to do to protect seniors and Medicare. And I think it's very important for my colleagues to understand these differences as we proceed over the next few weeks. So I'm very proud of the fact that on Friday we will be celebrating the second anniversary of President Obama signing the Affordable Care Act. And I'm also proud of the fact that as a Democrat, we are going to oppose the Republican budget. When the Republican budget was proposed last year, it passed the House, but it didn't pass the Senate, and we heard nothing more about it. And that's exactly what we plan on doing this year, because we can't allow Medicare to be destroyed. We can't allow the Medicare guarantee to disappear. We can't allow Medicare to basically wither on the vine, as former Speaker Gingrich said, as it's vouchered and as it's privatized, as the Republicans suggest in their budget. With that, Mr. Speaker, I would yield the balance of my time.
Under the Speaker's announced policy of January 5, 2011, the gentleman from Georgia, Dr. Gingrich, is recognized for 47 minutes.